Okay, welcome everyone to today's hotspot, contractor or not. And I'm Audrianne Adams Lee from HR Network, and on with me is Shannon Jenkins. Hi, Shannon.
Hi, good morning, everyone.
So we are recording this. At some point, it'll be available on our website if you want to come back and listen to it or have anybody else from your organization listen to it. I know that we have one or two more that may join us, but we'll go ahead and get started. I want to make sure we leave enough time for questions and answers. So here we go. Okay, so what is an independent contractor? And we know this is an area or an issue where people get confused by, are they a contractor or the employee? Can I just make them a contractor? And the answer is not necessarily. They need to qualify for as an independent contractor, and we're going to talk about several ways in which they qualify. But generally, an independent contractor is a person who contracts to provide a service or perform a function for others. Sometimes we call them freelancers, consultants. They may be self-employed, entrepreneurs, business owners. But generally, there is a contract in place for an exchange of services of some sort. So who can qualify as an independent contractor? And generally, most people who are in business for themselves. And if you look at all the little icons on this picture, you'll see there's a lot of organizations who are quite concerned with if you've called a worker, a contractor, or an employee, how you've classified them. And one of the reasons that all these folks are so concerned about it is they have a piece of the pie of getting from an employee. So when an employee is under your business as an employee, payroll taxes paid on them, workers' compensation is paid on them, wages are paid on them, and proper wages, etc.
Okay, well, with regard to all these different agencies, you see agencies at the state and the federal level. And as it exists right now, and we're going to talk a little bit about this, each of these agencies has a different test for what constitutes an independent contractor. They're all after a piece of the pie, as Audrianne indicated. But you have an IRS right to control test. You have a common law right to control test, which is used for ERISA purposes. You have a Treasury version of the common law right to control test, which is used for Affordable Care Act purposes. You have the FLSA, which is the federal wage statute, using what's called an economic realities test. You have different tests for independent contractors with different states, and within those states, you have different tests under wage and hour laws, workers' compensation, and unemployment. Focusing just, for example, on one of these, you've got the NLRB, which is the National Labor Relations Board, which usually you associate with union activity, but it also applies to private workplaces. Had 10, and within the last 2 years has added an 11th factor that it reviews, including whether or not an individual is in fact rendering services as an independent business, versus the so-called entrepreneurial opportunity, which we've always included in our factors, and you'll see these as we go through the presentation here, which is the opportunity of the contractor to determine how much their wages are going to be. As we know, as an employee, the employer sets those wages, but as an independent contractor, one of the things that we usually look at is how much opportunity the individual has to determine the outcome. If they work more, they get paid more. If they work less, they get paid less. That's a factor under independent contractor. Well, what the NLRB has done is said, we are going to focus on what the person has actually done, whether they have actually rendered services as an independent business, rather than looking at a theoretical opportunity to make more wages or less wages depending on their productivity. So it is very complicated and differs from agency to agency. Okay, go ahead, Audrianne.
Okay, so we're going to look at some of those tests. Let's continue on. Okay, so the IRS 20 points is one of the tests, and they look at things such as um, how the work is done, does that person have, can they have profit or loss based on the work they do they provide the work for others, not just you, do they use your equipment to do the job, do they sit at a desk in your facility to do the job, do they have a business card with your logo on it, but most importantly, the factors that the IRS looks at is who directs and controls the work. You know, if you think about an independent contractor, you don't really tell an independent contractor or somebody that you hire to provide a service for you exactly how to do that service. You hire them for an end result that you would like to see accomplished, and how they go about getting to that end result is how they do their business. And you don't necessarily tell them to do that. So the more you control the work of that worker, the more likely they may not qualify as an independent contractor. So we suggest that, you know, in these kinds of situations, that you do things like, if there is a business card, it says independent consultant or independent contractor for your company name, that they don't relay themselves as an employee, that you don't treat them the same as you treat other employees, that you don't give them an employee handbook to review, and that you don't necessarily provide them equipment and or a workspace to do it unless it's for a limited period of time.
Okay. I think it's just to follow up on that. There is a list of things that you can do to minimize the risk, but the most important factor, as Audrianne mentioned, is that right to control, and that is to be distinguished. And there's been jurisprudence on this. That is to be distinguished from the actual exercise of control. So if you retain the right to control how the contractor does their work, then that will be sufficient to find that they are actually an employee, not an independent contractor, even if you actually never pull the trigger on that.
Okay. Okay. So just recently, as part of the new law that came out, or a new interpretation, the Department of Labor is saying instead of using the IRS 20-factor test that we just talked about, they want to use the economic realities test under the Fair Labor Standards Act. So, so what is that? Well, the 6 factors are: they look at the extent the work is performed. Is it an integral part of the business? In other words, you know, if it's an integral part of the business, then potentially it may not, and they may not be an independent contractor. Whether the worker's managerial skills affect opportunity for profit and loss. And again, this has to do with impact to the business. If they have that big of an impact to the business, they may not be an independent contractor. Relative investments in the facilities and equipment by both the worker and the employer, the worker's skill and initiative, the permanency of workers' relationship with the employer. And, you know, one of the things I look at here, I will often see independent contractor agreements, and they don't have a start and end date. They just go on and on and on. And if you've got an independent contractor that's been working for you regularly for, you know, over 2 years, then it really gets called into question, is that person an independent contractor? And so that's one of the things to look at, is how long has that person worked for you? Do they have a specific date of which they will provide the service? And then again, we go back to the nature and degree of control by the employer.
You know, Audrianne, just to jump in here, I've had a number of clients contact me recently who are under the misunderstanding that just because you do have kind of a short term for the engagement, that automatically would permit you to classify somebody as an independent contractor. This arises when you have people who want to try out potential employees, for a period of time, see how they fit with the office, or see if they could perform the duties. So they think that because they hire them to work there for a day or a few hours or maybe a few months, that they can get around the fact that these people are, in fact, laboring as employees. You can't. If they are doing the work of your business, doing what your business does for you, they are suffering or being permitted to work and will probably be considered an employee instead of an independent contractor, even though the duration of their employment is very short. In that case, what you might want to do if you want to try out an employee is either hire somebody from a staffing agency or hire the worker as a temporary employee. And at least you're classifying and paying them properly and not risking that independent contractor liability.
That's a great point, Shannon, and I've actually had a few questions from clients recently, so as well. So I'm going to kind of talk about some of the situations that we've had. Recently, a client asked, can we have a working interview, and while they're so we can try them out and make them a contractor? And the answer is no. If you consider it part of the interview, they would have to get paid. And as Shannon pointed out, one thing you can do, a lot of employers don't realize this, you can hire them as your own temporary worker. Now, they're still subject to all the employment laws and wage and hour, et cetera, but your offer letter would specifically state this is a temporary position for 5 days, 7 days. So therefore, during the period of time that you are not a regular employee, you will not be eligible for any company paid benefits, except those required by law. So you can actually classify somebody and put them on your payroll, but classify them as a temporary employee. Okay, let's go on. Okay, so I think we could learn a good lesson last year. As you probably heard, Uber ended up with a major misclassification lawsuit where their employees brought up that they didn't really feel they were contractors because they were going out and paying for all their own expenses and not really getting any reimbursement for them. And so they brought up the question of, are we employees or are we contractors? And I'm going to let Shannon talk about that lawsuit for just a minute, and then I'm going to kind of come back and talk about some other concerns when you misclassify.
Okay, so Uber drivers filed a class action lawsuit claiming that they were misclassified as independent contractors and are entitled to be reimbursed for their expenses. As you know, our Labor Code 2802 requires employers to reimburse their employees for expenses. In this case, it would be for gas and vehicle maintenance. That particular lawsuit also challenges Uber's practice of telling passengers that the gratuity is included and not to tip the drivers, even though drivers are not otherwise getting a tip. That trial is actually set for June 20th, 2016. So we're going to see a lot of activity on this at the federal level very shortly. Uber had attempted to bring a summary judgment motion, which is a quicker adjudication of the issue of whether or not they're actually independent contractors. The judge denied that summary judgment motion. The case will be going to trial. The lesson, and I'm not sure, how Uber necessarily could have done it differently from the beginning because they have a really unique business model. But there are, being a digital platform, but there are some takeaways, and I think our next slide actually is on how we can minimize the risk of having somebody classified as an independent contractor. Whether or not you're an Uber and you operate on that digital platform, or you're just a brick and mortar business and you're wanting to contract with vendors or third parties who are going to come into your workplace and render services. So you want to go through some of those tips and tricks, Audrianne?
Sure. Okay, so we're going to talk about 11 ways to preserve contractor status. I first want to, before we even get into our list, employers will ask me, how would it come up that somebody would even review the status of a worker that's classified as a contractor versus an employee. And there's really two very common ways that this kind of ends up showing up. One way is, let's say the worker gets injured, either at your workplace, your client's workplace, on the way to your workplace. And a lot of contractors, at least prior to Obamacare, did not have health insurance. So let's say they get injured and they suddenly say, who's going to pay for my medical bills? I was doing work for this employer, for this company. I feel like based on doing that, they should pay for my medical bills. So they go file a claim with the DWC. And of course you say, well, no, they weren't an employee, they were a contractor. The DWC is going to come in and take a look at that and decide if they thought they were a contractor or not. And by the way, if you don't ask your contractor to provide a certificate of workers' comp insurance when you engage them, then you're going to be on the hook for the workers' comp for that contractor anyway. So that's one way. The other common way I've seen in the past is a independent contractor pays all the employment tax, as opposed to an employee. When they're an employee, you and the employee split the employment tax. Each pay 7.5%. But an independent contractor pays self-employment tax at 13%. Well, if they don't pay their taxes properly and they get audited by the IRS, and then they end up getting hit with a big tax bill, they say, well, wait a minute, why should I have to pay all these taxes? I was doing work for this company, so guess who's coming in to audit you then? It's the IRS. So, and what is the cost of misclassifying a contractor? Well, let's say you had somebody working for you 6, 7, 8 months, doing a job. Maybe they worked overtime, or worked more than 40 hours in some weeks. You didn't really measure that because you weren't paying overtime. You were paying straight time. You might even have been paying a straight amount per week. You didn't see if they were taking meal periods and rest breaks. You didn't reimburse them for any expenses. And then one of these agencies comes in and audits you and decides, yes, that person should have been an employee and they were misclassified. You now potentially are also on the hook for unpaid wages, unpaid overtime, missed meal period and breaks, etc. So the cost can be really, really expensive, and it's just not worth taking the risk on that.
For those of you who've attended our seminars also for over the years, will recall a few years back that a new law went into effect which provided a penalty ranging from $5,000 to $15,000 per violation for isolated violations, increasing to $10,000 to $25,000 per violation for misclassifying somebody as independent contractor. And also nailed for penalties those who were paid advisors advising people to willfully misclassify people as independent contractors. So yeah, in addition to the underlying wages and everything that would be owed, you've got this heap of penalties on top of it.
Okay, so let's talk about some ways to preserve contractor status. And so these are suggestions in order to minimize your risk. So obviously, first and foremost, do not control the work. When you hire a plumber, for example, you don't tell the plumber how to do his plumbing work. You hire him to fix the problem or come in and address an issue. You expect them, being an independent contractor, that you're hiring them, they know their business, they know how to get their business done. You need an end result. Number 2, do not provide the training. Again, if you hired a plumber and you happen to be in the plumbing business and you wanted to train that plumber to do it your way, and that's the nature of your business, that would be a problem. So again, you shouldn't be providing training. They should be hired because they are knowledgeable in the area of what you're hiring them to do. Allow the worker to establish his or her own working hours when possible. So again, if I have a contractor and I say, we'd like you to come in here and do the work, and we want you here from 8 to 5, and you establish what those hours are or a schedule for that person, that's just another factor that doesn't look like this person is really a contractor. Do not dictate where the worker should perform the work. Again, it's not necessary that they do it at your site unless they're coming in specifically to do something. And it may be necessary for them to come to your site periodically, but if they need to come in every day and sit at your desk using your equipment during your working hours, that's just another factor that they may not be a contractor. Do not include number 5, do not include in regular employee meetings or functions. I can't tell you how many times we want contractors to feel engaged, so we treat them just like employees so that they feel engaged. We invite them to all the staff meetings as part of, we invite them to trainings, we invite them to the holiday party, etc. But again, the more you treat a contractor like an employee, the less it will be defendable to say, no, they're a contractor. Any thoughts on this before I move to the next slide, Shannon?
I agree with all of that, Audrianne.
Okay, we'll move on. Okay. All right, number 6, do not provide them an employee handbook or other rules for employees. One of the things that we've done for clients and is a good suggestion is we've created a manual that is for outside services or outside vendors, because you still want outside services and vendors to follow certain rules and expectations of the way you do business. In other words, you don't want them to harass your employees, nor do you want them to be harassed. You want them to know that you follow those business laws that are required of a company, and when you do work with other vendors, you want them to follow the laws as well. So you could create a vendor manual and provide that to your contractors, your vendors, etc., but not an employee handbook. Do not reimburse for business expenses. Again, because that reimbursing for business expenses is part of a labor code for employees. And whatever expenses a contractor might incur should be part of their cost of doing business. Do not provide them employee benefits. Again, the more you treat them like an employee, the less likely they're going to be seen as an independent contractor. Pay by the project where feasible instead of by the hour. So again, if I hired a plumber, I'm typically going to pay them for the project or the work they do. I'm not going to pay a plumber by the hour. And so it always looks better when you can pay by the project. Do not provide tools or other supplies. They should be providing their own tools or supplies. And then always use a written independent contractor agreement, and certainly one that's been reviewed by an attorney.
Okay, yeah, so just a couple of things to follow up on here. First of all, it is really important for item number 6 that you have some sort of a vendor manual or even just policies, loose leaf policies that dictate how people are going to behave regardless of what their classification is when they're on your work premises, because the Fair Employment and Housing Act expressly on its face and in its language prohibits harassment and discrimination against employees, applicants, unpaid interns or volunteers, or persons providing services pursuant to a contract. So believe it or not, you could get nailed for a harassment claim or a claim under FEHA, either directed at or resulting from the behavior of an independent contractor at your workplace. It's really important that we establish some guidelines about proper interpersonal interactions at the workplace. The other thing is and I noticed that Audrianne didn't put it on here, but I saw some communication between Audrianne and a client the other day where, Audrianne, you had attached an audit form for an employee to use to self-audit whether or not they felt like they met the test of an independent contractor. Can you describe that a little bit?
Well, okay, so the idea on that was for that person to acknowledge or recognize if they met the criteria of an independent contractor. So do they have their own materials? Do they have their own workers' comp insurance? Do they meet the criteria? And again, so involving that person to make sure that they meet the qualifications.
But that was actually something that you pulled from an agency website.
Yes, it was. I'm trying to recall I don't recall what agency. But we do have a couple of pieces that people who have joined us today, we can share with you. We can share with the IRS 20 points. I'll share that agency. I want to say it was from the DOL, but I'm not exactly sure. But we can share that piece with everyone at the end of the seminar today.
It was an EDD contractor worksheet?
Yes, it was. You're right, EDD. So I'd be glad to send that out.
Very helpful. I thought very helpful for people to kind of question them at each step of this analysis. Okay.
So as we pointed out before, there are 6 agencies concerned about contractors. The EDD, of course, is concerned about you paying into the disability system, that you're paying proper taxes, the unemployment insurance system, etc. Division of Workers' Comp wants to make sure that every worker is covered in California. Whether they are an independent contractor, then they should have their own certificate of workers' comp insurance, or whether they're your employee. The DOL, both the federal DOL and then, of course, the California Labor Commission, wants to make sure workers are paid properly. And so they want to make sure that they're getting proper wages, overtime, that you're following labor codes, etc. Of course, the IRS is concerned that proper taxes are being paid. And Immigration and Customs wants to make sure you're not trying to sidestep potentially somebody who may not be a proper employee and may not meet the qualification, that may not meet the legal requirements for an employee, so you try to sidestep and hire them as a contractor. Okay, so that's it. Do we have any questions? I want to open it up, and let's see, I need to unmute you.
Audrianne, while you're doing that, let me just jump in here. A lot of these agencies do have opportunities for you to self-audit, and just jumping on the IRS website, you will find that it asks you to ask yourself some of the same questions, but it also provides what's called a Form SS, which you will complete and then submit to the IRS, and they will assist you in determining whether or not somebody is in fact an independent contractor or an employee. So there's a lot of resources out there, and you can work with your attorney or your CPA on making sure that your people are properly classified.
Okay, so I've opened up the phone line here, and so does anyone have any questions that they'd like to bring up?
Hi. When you unmuted, I actually missed what was the name of the form.
A Form SS-8.
SS-8. Okay.
Any other questions?
Yes, I own a veterinary hospital, and at times we need to not be there as doctors, so I hire a relief veterinarian through relief service. These doctors are there only for a day, maybe 2 to 3 at the most. They, as going through those preserved contract status rules, the only thing is that they do have to have certain working hours because the hours that the hospital's open. But everything else, other than tools that we provide, everything else is fine. Do we still need to have them as an employee for that day?
On this is Shannon. You say that you hire them through a service?
Yes.
Okay, and the service is the one who pay, and are they employees of the service?
No, I pay the service a finder's fee, and I pay the relief veterinarian for the day of service.
That's obviously a tougher situation than if you had somebody who was coming in and rendering services which were not part of your business. And remember, there's no one factor that's determinative. So one of the factors we look at is the doctor coming in and doing what it is that your operation exists to do? Well, the answer to that particular question is yes. However, that person will pick their shifts. Presumably, that person will set their fees. You will have they will use some of your tools and implements. They may bring their own. And so I think in that case, I think it could probably go either way. What I would like to see is, do you have any sort of an independent contractor agreement with them, and how do you bill them? Or how do they invoice you?
They tell me, they offer me I send out an email saying I need relief work for May 1st. They say, hey, I can work it for $600 a day. I go, okay. They come in, they work, I leave them a check.
Now, what if something happened and they malpractice? I'm just saying, I'm sure they wouldn't, but what if something happened and they did?
As far as a doctor goes, we all have our own liability insurance as independents.
How do you know that they do, though? Do you verify that?
On the website for the relief veterinarians, they state that they have their own health insurance, they have their own liability insurance, they state their doctor license number for the state.
I would probably say that the last piece that you would want to get in there is some sort of a written agreement with them that they recognize and agree that they're not your employees, that they will file their own taxes, and that they will indemnify you from any misconduct which occurs as a result of their work. So that should be in some sort of a written agreement, which we would style as an independent contractor agreement, so that there's no claim ever down the line that they could be considered employees. We have a similar arrangement in the legal field where sometimes we'll have, not my firm, but firms do use independent contractor, what we call appearance attorneys, to make appearances for you. You know, obviously making appearances is part of your job as a lawyer, but if you want to hire somebody to go make your appearance in court for the day, you know, that type of a transaction exists. And so I'm sensitized to that, but I think you could get that written contract as the last piece of business.
Okay. Any other questions before we wrap up? Okay, so as I mentioned earlier, we will send out the PowerPoint, and we will send out a couple of add-on pieces that, including the checklist Shannon was referring to earlier from the EDD and the IRS 20-point checklist. And then once you've had a chance to review that, if you have any questions, feel free to call either myself or Shannon back. We'd be, of course, we'd be glad to help you.
Thank you.
Thank you.
Okay, thanks everyone. Have a good day.